Civics, Congress for Lawyers, Congressional Procedure, Chapter 1, Congress and the Constitution. Table of Sections. Introduction. B. Constitutional Provisions. C. Rules. D. Congressional Terms. E. Members of Congress. F. House of Representatives. G. Senate. H. Congressional Committees. I. Review questions. A. Introduction. The Constitutional Convention called together in Philadelphia in 1787 was merely expected to amend the Articles of Confederation to repair its defects arising principally from the weakness of the central government that it created. Among its inadequate provisions was the Congress it created, a weak and incompetent body beholden to the states for many of the essential functions of national government. But the convention undertook to create a new constitution. The founders created a new Congress in the first article of the Constitution. The bicameral institution they designed included the House of Representatives and the Senate. Article 1, Section 1 declares, all legislative powers herein granted shall be vested in a Congress of the United States, which shall consist of a Senate and House of Representatives. The founders had high hopes for Congress. They understood that a strong legislature is fundamental to a healthy democracy. At the same time, they feared a central government that was too powerful. To restrain that power, they created a constitution that divides power among the branches of the federal government, separation of powers, and between the federal government and the state, federalism. They set up an elaborate system of checks and balances among the three branches of the federal government, executive, legislative, and judicial, to assure that no one co-equal branch could dominate. Of course, the way Congress is organized and its procedures play a huge part in public policy decisions and outcomes. The division of Congress into two chambers with differing structures was intended to create bodies with differing roles. James Madison explained in the Federalist Number 51 that the legislature was itself divided into different branches and to render them by different modes of election and different principles of action as little connected with each other as the nature of their common functions and their common dependence on the society will admit. The design purposely created one chamber, the House, to be closer and more immediately responsive to the electorate, and another chamber, the Senate, to be more insulated from the winds of popular opinion. In the famous, probably apocryphal story, often used to illuminate this difference, George Washington explained the need for a Senate to Thomas Jefferson. Jefferson, who was in France during the deliberations of the Constitutional Convention, asked why a second body, an upper body, was even necessary. Washington is said to have compared the Senate to a saucer used in the polite society of the day to sip from in order to cool the tea poured from the cup. The House of Representatives, the dispenser of hot tea, is sometimes referred to as the People's House. Given shorter terms of office, 2 years, and smaller and usually more homogeneous constituencies than the Senate, 6 years, the House was expected to act more quickly in response to public opinion. The House has developed rules that provide the ability for a majority to respond in this way. The Senate, Washington's cooling saucer, by contrast, is sometimes referred to as the world's greatest deliberative body. James Madison referred to the Senate as a necessary fence against the fickleness and passion of the popular will and the members of the House of Representatives. Like other checks and balances in the Constitution, the division of Congress into two separate, different chambers serves to protect against the concentration of power within Congress. The framers nonetheless expected that the legislative branch would prove to be most powerful of the three branches. As Madison argued in the Federalist Papers, the legislative branch necessarily predominates to guard against concentration of legislative power. The founders created a system in which neither chamber is able to make laws alone. See also related CRS reports and links on tcncpam.com. B. Constitutional provisions. The Constitution, in Article 1, extensively lays out the powers of Congress. Central to the congressional role is the grant of all legislative powers and the power of the purse. At the Constitutional Convention in 1787, Massachusetts delegate Elbridge Gerry, later James Madison's vice president, argued that the House of Representatives was more immediately the representatives of the people, and it was a maxim that the people ought to hold the purse strings. Article 1, Section 8 lists a number of specific powers, including in Clause 18, necessary and proper clause, the power to make all laws which shall be necessary and proper for carrying into execution the other listed powers. This is often referred to as the elastic clause because it gives flexibility to Congress beyond the powers that are separately enumerated. An example of an early use of the elastic clause was the justification for the Louisiana Purchase in 1803, roughly doubling the size of the United States at the time. A strict reading of the Constitution would find no authorization for the purchase of foreign territory, but it was argued that the elastic clause allowed the action and the Senate ratified the treaty. Among the enumerated powers are the power to lay and collect taxes and pay the debts, Clause 1, borrow money on credit, Clause 2, regulate commerce with foreign nations and among the states, Clause 3, create the courts below the Supreme Court, which is created in Article 3, Clause 9, raise and support an army, Clause 12, and navy, Clause 13, the power to declare war, Clause 11, and others. Article 1 takes up more space in the Constitution than Articles 2 through 7 combined. By comparison, the descriptions of presidential power, Article 2, and those of the courts, Article 3, are less precisely stated. Among the provisions of the Constitution affecting the Congress, Several are of particular importance. Article 1, Section 2 stipulates 2-year terms and sets the necessary qualifications for members of the House. Section 3 does the same for senators, creating 6-year terms and the qualifications for senators. See Chapter 1E ahead. Article 1, Section 7, Clause 1, commonly referred to as the Origination Clause, states, all bills for raising revenue shall originate in the House of Representatives, but the Senate may propose or concur with amendments as on other bills. The framers gave the power of the purse, as Elbridge Gerry referred to it, at the 1787 Congressional Convention, to Congress, specifically to the House of Representatives. Madison wrote in the Federalist Papers, number 58, the House of Representatives cannot only refuse, but they alone can propose the supplies requisite for the support of the government. This power over the purse may, in fact, be regarded as the most complete and effectual weapon with which any constitution can arm the immediate representatives of the people. The House of Representatives can not only refuse, but they alone can propose the supplies requisite for the support of the government. This power over the purse may, in fact, be regarded as the most complete and effectual weapon with which any constitution can arm the immediate representatives of the people. The House enforces this constitutional prerogative through the use of a process called the blue slip. But in the event that the Senate passes a revenue bill and sends it to the House, any member of the House may offer a resolution that the Senate bill violates the prerogatives of the House under the origination clause of the Constitution. Such resolutions are routinely adopted, often by voice vote, and the bill is returned to the Senate. The blue slip takes its name from the fact that the message returning the bill to the Senate is blue. This is, however, a bit of a misnomer since all messages from the House to the Senate are on blue paper. The House has historically viewed revenue bill as encompassing tax and other revenue bills, as well as appropriations measures that spend government funds. The Senate interprets revenue bill more narrowly and contests whether appropriations bills are included. However, the blue slip process has rendered Senate objections in this regard relatively toothless. Central to the independence of Congress are the protections provided by Article 1, Section 6. Senators and representatives are not subject to arrest during sessions or when traveling to those sessions, with the exception of arrests for treason, felonies, or the breach of the peace. Further, the Speech and Debate Clause prohibits questioning of members of Congress in any other place regarding what they say on the floor of the House or Senate. Article 1, Section 6 also stipulates that no member, while serving in Congress, may hold any other federal office. As a result, when senators or representatives are appointed to the cabinet, for example, they must resign their congressional office before taking the oath for their new position. One additional noteworthy congressional power is granted in Article 2. In Section 4, the Constitution provides that the President, Vice President, and other civil officers may be removed from office on impeachment for and conviction of treason, bribery, and other high crimes and misdemeanors. Early in Article 1, Section 2, it is the House of Representatives that has the sole power of impeachment. Section 3 then grants the sole power to try all impeachments to the Senate. The Chief Justice of the United States presides over an impeachment trial of a president in the Senate, and a two-thirds vote of senators present is required for conviction and removal. The House has voted to impeach a president only twice: Andrew Jackson in 1868 and Bill Clinton in 1998. In both cases, the president was acquitted by the Senate. In 1974, Richard Nixon resigned the presidency in the face of what appeared to be certain impeachment by the House and subsequent conviction by the Senate. The Constitution has been amended to provide additional power to the Congress. In 1967, the 25th Amendment was ratified. In the event of a vacancy in the office of the Vice President, it provides for the nomination by the President and confirmation by a majority vote in each chamber of Congress of an individual to fill that vacancy. The amendment also creates a procedure for the Vice President to become acting President if the Vice President and a majority of the Cabinet declare the President unable to discharge his or her powers and duties. It further prescribes a process for resolving the matter if a president asserts, contrary to such declaration, that he or she is capable of discharging those duties. Under these circumstances, the president will resume his or her power and duties unless, by a two-thirds vote of each chamber, Congress determines the president is unable to do so. See Chapter 8, Section H. Under Article 5 of the Constitution, Congress plays a central role in adopting amendments to the Constitution by a two-thirds vote of each chamber, ratified by two-fourths of the state legislatures. See Chapter 8, Section Q. See also related CRS reports and links on tcncpam.com. Section C, Rules. Perhaps one of the most critical protections of congressional independence and power is Article 1, Section 5 of the Constitution, which states in part each House may determine the rules of its proceedings. Pursuant to this provision, the House and the Senate have developed very different rules. Those rules have established the character of each chamber in ways that enhance their constitutional design. The House of Representatives adopts its rules at the outset of every new term of Congress, every 2 years. These changes can be minimal. From the previous Congress, when control of House changes parties, the rules changes are more likely to be extensive. For example, in 1995, when House Republicans became the majority for the first time in 40 years, newly elected Speaker Newt Gingrich, Republican of Georgia, led the Republican conference to a major overhaul of the House rules. The rules of the House are adopted by majority vote. The rules, precedents, procedures, customs, and mores or mores of the House serve to protect the principle of majority rule. The formal rules are set down in the House Rules and Manual, which contains the foundation for the parliamentary procedure followed by the House, including the adopted rules of the House portion of Jefferson's Manual, the Constitution, relevant adopted resolutions, and House precedents, which are rulings made by the Speaker and other presiding officers. The Senate standing rules, precedents, and practices are designed to protect legislative minorities and the rights of individual senators. The rules adopted by the First Senate provided for a previous question motion. However, the rule that permitted a senator to limit debate by moving the previous question by simple majority vote was dropped in 1806. The House of Representatives has a previous question rule. When the motion is made in the House, I move the previous question. If agreed to, debate and further amendment is ended, and the House moves to vote on the matter before it. Most legislative bodies have such a motion in their rules. Today we understand such motions as requiring an end to debate and an immediate vote on the pending matter. In the House of Representatives, this motion to cut off debate requires only a simple majority vote. The absence of such a rule in the Senate now permits what is commonly known as the filibuster. Filibusters characterized by extended debate and or dilatory tactics can be ended under Senate Rule 22 through a process called cloture, requiring a supermajority of three-fifths of the senators, duly chosen and sworn, 60 votes with some exceptions. See Chapter 5, Section H. This has a broad range of implications because it requires the majority in many circumstances to consult or negotiate with the minority even in the routine workings of the Senate. While the early Senate rules includes a previous question motion, the evidence is that it served a different purpose. While the early Senate rules included a previous question motion, the evidence is that it served a different purpose. A scholarly essay by Johns Hopkins University professor Joseph Cooper concludes that the previous question, as it existed in the early Senate of 1789 to 1806, was not designed to operate as a cloture mechanism. It was not in practice used as a cloture mechanism, and it is even improbable that the Senate could have used the previous question for cloture. Footnote Joseph Cooper, previous question. It's standing as precedent for cloture in Senate. Senate document number 87, 104, 87th Congress, second session, Washington, U.S. Government Printing Office, Volume 2, Serial 12445, 1962, 26 dot back. Unlike the House, where the rules can and frequently do change with each Congress, the Senate adopted its rules in 1789, and although they have been amended and codified, the basic rules have been continuously in place. Because the Senate considers itself a continuing body, it does not adopt its rules at the beginning of each Congress. This is based on the fact that only one-third of senators stand for election for each term of Congress. One-third of the senators are to be elected every 2 years, divided as equally as may be into three classes. Article 1, Section 3, Clause 2. Since the remaining two-thirds are already chosen and sworn, and since a quorum in the Senate under the Constitution is a majority, there is no period of time during which a quorum of the Senate does not exist. In 1903, the Senator Henry Cabot Lodge, a Republican of Massachusetts, described it best. Administrations come and go. Houses assemble and disperse. Senators change, but the Senate is always there in the Capitol and always organized with an existence unbroken since 1789. Even though Senate rules can be changed by a simple majority vote, the Senate rules that continue from one Congress to another do require a two-thirds majority of senators voting to end debate on any rules changes. See also related CRS reports and links on tcncpam.com. Section D, Congressional Terms. Each term of Congress lasts for a 2-year period from June 3rd of odd-numbered years. Terms are commonly divided into 2 sessions of Congress, although more are possible, either convened by the Congress or by the President, calling Congress back into session. See termsofcongress.com. The President, under Article 2, Section 3, is granted the power to On extraordinary occasions, convene both houses or either of them. A session ends when the Congress adjourns, sine die, Latin meaning without any day set to reconvene. When a Congress plans to reconvene a second session following the general election in November of even numbered years, it does not adjourn sine die. The period after the election up to the sine die adjournment at the end of the second session is popularly referred to as a lame duck session. The transition from the first session to the second session at the end of the first calendar year of a given Congress ends the consideration of nominations but has no effect on the progress of legislative matters. However, when the Congress adjourns sine die at the end of the 2 year term, all legislative matters die. Therefore, in order to advance any bill or resolution in the next Congress, it must be reintroduced. An exception are treaties submitted to the Senate by the President for ratification, which carry over from one Congress to the next. Section E, Members of Congress. The Constitution stipulates in Article 1, Section 2, that the House of Representatives must have at least one representative from each state. Further, it provides that members of the House serve 2 year terms, must be at least 25 years old, have been an American citizen for at least 7 years, and must reside in the state, although not necessarily the district, from which they are elected. Article 1, Section 3 states that each state is represented by the Senate by two senators elected for 6 year terms who must be at least 30 years old, have been a citizen for at least 9 years, and must also be a resident of the state from which they are elected. Congressional elections occur every 2 years. Since members of the House serve 2 year terms, all the House of Representatives is elected in each congressional election. Elections for members of Congress held in the even years between presidential elections are called midterm elections. By contrast, senators serve 6 year terms. The Constitution established a rotation in which one of three classes of senators is selected at each congressional election. See SenateClasses.com. This means that only one-third of the Senate stands for election every 2 years. Article 1, Section 3 stipulated that senators would be chosen by individual state legislatures. The 17th Amendment, ratified in 1913, changed the process and provided for direct election of senators in each state by the people thereof. The House currently consists of 435 members, a total set by law in 1913 and reaffirmed by the Permanent Apportionment Act of 1929, 2 U.S.C. Section 2A. The District of Columbia is represented by a non-voting delegate. In addition, Guam, the Virgin Islands, American Samoa, and the Northern Mariana Islands each has one delegate. Puerto Rico is represented by a resident commissioner. These six representatives do not vote or These six representatives do not vote on final passage of matters on the House floor, but possess all other powers of members. Members of the House represent districts drawn by their states, which are roughly proportional to population, based on the census that the Constitution requires to be conducted every 10 years. In some states, district lines have been drawn to benefit the political power. In some states, district lines have been drawn to benefit the political party that controls the state legislature, a practice known as gerrymandering. California, the nation's largest state, as measured in the 2010 census, is represented by 53 members of Congress, while Alaska, Delaware, Montana, North Dakota, South Dakota, Vermont, and Wyoming have only one representative. There are 100 senators, two from each state. This equality of state representation in the Senate was the product of the Great Compromise at the Constitutional Convention in 1787. Small states pressed for equal representation in Congress, and the larger states sought proportional representation for both chambers of Congress. The compromise created one chamber based on each principle. As a result, Wyoming, in 2008, population of approximately 600,000 people, has the same representation in the Senate as California, 2018 population of more than 39 million people. Interestingly, that compromise was deemed so fundamental to the establishment of a federal government that it cannot be changed using the normal means of amending the Constitution. Article 5 states, "No state, without its consent, shall be deprived of its equal suffrage in the Senate. Members of the House and Senate may only be removed from office by a two-thirds vote of members voting, a quorum having been established of the Senate, if a senator, or the House, if a representative." The Constitution defines a quorum in Article 1, Section 5. A majority of each chamber shall constitute a quorum to do business. There is no recall provision allowing for removal of members of Congress by popular vote prior to regularly scheduled congressional elections. Section F. House of Representatives. The House of Representatives is a majoritarian body. This means that the House is ruled strictly, at most times, by majority vote. Under the Constitution, Article 1, Section 4, as amended by the 20th Amendment, the Congress shall assemble at least once in every year. Under that provision, the first meeting of each Congress shall begin at noon on the third day of January, unless they shall by law appoint a different day. Members of the House serve 2-year terms. Vacancies in the House are filled by special election. Article 1, Section 2. There is no provision for appointment of members to the House. Regarding leadership, Article 1, Section 2 of the Constitution states, "The House of Representatives shall choose their Speaker. This is done by majority vote of the whole body at the outset of each new Congress. Party caucuses nominate candidates, and normally the election takes place between the candidates nominated by the Democratic and Republican caucuses, respectively. On occasion, the names of additional candidates are placed in nomination. The Speaker under existing law is second in line of succession to the presidency behind the Vice President in the event of the death or disability of the President." See Chapter 8, Section P. House party leaders, the majority leader, the minority leader, the majority whip, the minority whip, and others are elected by majority vote of the respective party caucuses. At the beginning of each Congress, the leadership is elected on the first day. See congressleaders.com. The Speaker is presiding the Speaker is the presiding officer of the House. Speakers have in the past viewed themselves leaders of the whole House as well as a party leader, and have protected that distinction. Bob Mitchell, Republican of Illinois, who served as minority leader for 14 years from 1981 to 1995, but never became the Speaker, described the role of Speaker as, by history, tradition, and rule, the leader of the whole House, not the majority, not the minority, but the whole. The Speaker must drop the mantle of partisanship the day he assumes office. Footnote 2, Congress, Speaker O'Neill, hardball or hand grenades, New York Times, June 7, 1984, accessed March 5, 2018, http colon // www.newyorktimes.com /1984 /06 /07 Congress Speakero Neil Hardball or hand grenade html back, which probably means the Wayback Machine. As the House has become more partisan, speakers have been increasingly viewed predominantly as party leaders. Michelle Mitchell, contrasting his com- com- comfortable relationship with Democratic speakers Tip O'Neill, Democrat of Massachusetts, and Tom Foley, Democrat of Washington State, with the much more vitriolic leadership relationships of minority leaders with later speakers like Newt Gingrich, Republican of Georgia, or Nancy Pelosi, Democrat of California, John Boehner, Republican of Ohio, and Paul Ryan, Republican of Wisconsin. Observed in 2008 with Tom and Tip Egads. We got along. Sure, we had our doggone partisan differences. I expect that. You can't be namby-pamby about it. But when push come to shove, or during a real nitty-gritty situation, why, I always knew that I could talk with either one of them on a simple man-to-man basis and no holds barred. And that's a good feeling to have. Footnote 3, Robert Mitchell dies at 93. House GOP leader prized conciliation. New York Times, February 17th, 2017. By tradition, the Speaker normally does not cast a vote. When the Speaker votes, it underlines the importance of the measure in question. The Speaker, as the presiding officer under House rules, has the power sometimes delegated to other senior members of the majority to recognize members to speak or make motions on the floor. This is important because it gives the Speaker greater control over debate and amendment on the floor. The Speaker refers legislation to committees of jurisdiction and names members of conference committees with the Senate. Conference committees are temporary joint committees appointed to resolve differences between the chambers on a measure passed by each. See Chapter 6, Section D. The Speaker is also afforded powers by the Majority Caucus, including a central role in the assignment of members to committees, particularly to the powerful Rules Committee. The Speaker, as a practical matter, controls what legislation is scheduled on the House floor. The powers given to the Speaker are intended to assure that if he or she can marshal the votes of the Majority Caucus, the Speaker is able to largely control the legislative outcomes in the House. When sizable factions oppose a Speaker in his or her own party, such control is in doubt. The Speaker's job is particularly challenging when the majority party's margin in the House is narrow or when the majority is ideologically divided. Neither the Speaker nor the President pro tempore of the Senate is required to be a member of Congress, although historically all have been. The House Majority Leader is second in line of party leadership. He or she works with the Speaker on the legislative agenda and plays a key role in persuading members of the caucus to follow the leadership. The House Minority Leader heads the minority party and is the chief strategist in articulating the views of the minority party, frequently in opposition to the majority. He or she leads the minority's efforts to influence legislation. If the Speaker is able to keep the majority party in line, it can be difficult in the majoritarian House for the minority to have much effective input. However, there are times when the Speaker must rely upon members of the minority to pass legislation he or she considers critical. A recent example was a vote in 2014 to raise the debt ceiling and avoid a default on debts owed by the federal government. On that occasion, few members of the majority, 28, were willing to support Speaker John Boehner's, Republican of Ohio, position, and by the entire minority virtually the entire minority voted to lift the debt ceiling. Both parties elected a whip. Both parties elect a whip, third in line of majority leadership and second among the majority leadership. The party whips lead a large whip organization on their respective sides of the aisle. The main role of the whips and their organizations is to provide a channel of communication between the leadership and rank and file members. This is important to keep leaders informed of the various views in the caucus, to assist in persuading rank and file members to support the party position, and to keep track of the likely vote counts. Other members of the House leadership include the chairs of the Democratic caucus and the Republican conference. These two organizations are primary vehicles for party communication of the respective party's message on policy and legislation. Also in the leadership are the chairs of the National Republican Congressional Committee, NRCC, and Democratic Congressional Campaign Committee, DCCC. These are the political arms of the Congressional Republican and Democratic caucuses. They recruit candidates for House races across the country and raise and distribute campaign money to that party's candidates. For a list of the current leadership, see congressleaders.com. Section G, Senate. The Senate is a very different body than the House. In addition to the longer terms and larger, more diverse constituencies, there are several factors that account for this difference. The most important are the twin pillars of the Senate: unlimited debate and unfettered amendment. The Senate rules and precedents governing debate and offering the Senate rules and precedents governing debate and the offering of amendments are fundamental to the protection of legislative minorities. See Chapter 5. The Senate rules and precedents governing debate and the offering of amendments are fundamental to the protection of legislative minorities. See Chapter 5. The right to debate, enforced primarily by the existence of the filibuster, means that much of the routine activity of the Senate requires unanimous consent because the alternative is so time consuming and burdensome. Much of the business in the Senate, both routine and consequential, is conducted through unanimous consent agreements, often negotiated between the party leaders or their designees. The ability of a single senator to slow down or even prevent the Senate from doing business can make the Senate a very difficult body to lead. Former Republican Majority Leader Howard Baker, Republican of Tennessee, described it as herding cats. Increasingly, the political polarization of the Senate and efforts by the minority to use procedures to obstruct the majority or by the majority to circumvent the minority have rendered these procedural rules more controversial. James Madison wrote in Notes of Debates in the Federal Conventions of 1787, June 26, 1787, in order to judge of the form to be given to the Senate, it will be proper to view it will be proper to take a view of the ends to be served by it. In order to judge of the form to be given to the Senate, it will be proper to take a view of the ends to be served by it. These were first to protect the people against their rulers, secondly, to protect the people against the transient impressions into which they themselves might be led. The founders designed The founders' design for the Senate was contrary to legislative efficacy, or the founders' design for the Senate was contrary to legislative efficiency. Sir A. J. Herbert, the British humorist and member of Parliament, put it, the second chamber is an indispensable feature of any democratic constitution, for no one is always right the first time. Senate vacancies are filled differently, depending on the respective state's election laws. In contrast to how House vacancies may be filled, most states permit temporary appointment of senators, usually until the next scheduled congressional election. Some states, however, require a special election with or without provision for a temporary appointment until that special election. Article 1, Section 3 designates the Vice President of the United States as President of the Senate and stipulates that the Vice President is to have no vote in the Senate except in the case of a tie. Section 3 also authorizes the selection of a President pro tempore to serve in the absence of the Vice President. The President pro tempore, or his or her designee, presides over the Senate when the Vice President is not present. From the first Senate, senators have retained the important powers and keep the presiding officer of the body weak. The Vice President comes from the executive branch and may not be of the same party as a Senate majority. Rulings by the rulings by the presiding officer may be overturned in the Senate by majority vote. As a result, the President pro tempore's role is likewise relatively weak and largely honorific. The tradition in the Senate has been to elect the most senior member of the majority party as President pro tempore. This means that this officer, under current law, behind only the Vice President and the Speaker of the House, is in the line of succession to the presidency, can be more than 80 or 90 years old. See CongressLeaders.com. The most powerful role in the Senate is accorded to the Majority Leader, who is elected by the caucus of the majority party. The Senate itself takes no action to ratify this decision made by the majority party. The Majority Leader is generally regarded as the first among equals. He or she is given little in the way of formal powers. By precedent, the Majority Leader is given the right of first recognition. This means that although the Senate rules require the presiding officer to recognize a senator who first seeks recognition, when the majority leader is among those seeking recognition, he or she will be recognized. This, along with the power to decide the Senate's agenda, even this, because of the Senate rules of debate, requires negotiation with the minority leader, are the principal tools the majority leader uses to control the Senate. Notwithstanding the powers of the majority leader, little can be accomplished, even in the routine operation of the Senate, without negotiating with the minority leader. Former Majority Leader George Mitchell, Democrat of Maine, described this fact as creating a near permanent state of negotiation. With its checks and balances, the Senate is a microcosm of the American system itself. It's relatively easy to obstruct and prevent things from occurring. It's very difficult to gain enactment. As a practical matter, the tools given to the Senate Majority Leader are much weaker than those wielded by the Speaker of the House. Like the House, Senate leadership also includes party whips, formerly titled Assistant Majority Leader and Assistant Minority Leader, but commonly referred to as Majority or Minority Whip. Much like the whips in the House, these senators are charged with keeping track of votes in their respective caucuses and trying to persuade rank and file senators to support the caucus positions. The leadership includes others such as the officers of the Democratic Conference, the Democratic Policy and Communications Committee, the Democratic Senatorial Campaign Committee, DSCC, the Republican Conference, the Republican Policy Committee, and the National Republican Senatorial Committee, NRSC. The number of senators serving in the leadership in the Senate has gradually increased over recent decades, reflecting an effort by the parties to be more inclusive of factions and to assure that regional concerns are represented. Section H. Congressional Committees. Committee chairmen wield considerable power in both the House and Senate. At times when power is less centralized in the House and Senate leadership, committee chairmen have even greater influence. The more polarized the Congress, the stronger the centralized leadership in both chambers, the concomitantly the role of committees and their chairs weakens somewhat. On occasion, major legislation is written and managed through the Speaker's office in the House or the Majority Leader's office in the Senate. Nonetheless, much of the actual crafting of legislation occurs in committees in both the House and the Senate. For this reason, members, in order to influence legislation important to their constituencies, seek positions on the committees with jurisdiction over such legislation. For example, seats on the House Committee on Agriculture are typically filled by many members representing rural districts, being assigned to committees with jurisdictions over issues important to their constituencies is even more important in the House, where rank and file members have little opportunity to shape or amend legislation on the floor, as is more common in the Senate. Committees hold hearings taking testimony from administration officials, outside experts, interested stakeholders, and sometimes other members of Congress. Woodrow Wilson, a political science professor at Princeton before becoming president, wrote, "It is not far from the truth to say that Congress in session is Congress on public exhibition, whilst Congress in its committee rooms is Congress at work." In the 115th Congress, there are 21 standing committees in the House, including the Permanent Select Committee on Intelligence, while the Senate has 20 committees, 16 listed as standing committees. In addition, there are 4 joint committees that have members from both the Senate and the House, but do not have legislative jurisdiction. See congressleaders.com. Members are appointed to the House committees by the respective Republican and Democratic steering committees. In the Senate, the selection is made by the Republican Committee on Committees, and the Democratic Steering and Outreach Committee. However, in each chamber, the party leadership in each chamber makes recommendation, and these are generally adhered to. Once a nomination of a member to a committee is made, formal approval is granted first by the party caucuses and then the full House or Senate by the adoption of resolutions ratifying the choices made by each party. Normally, these approvals are virtually automatic. The overall size of committees and the party ratios of seats on committees are negotiated between the party leaderships. In the Senate, the expectation is that the ratio of committee seats assigned to members of the majority and minority parties respectively, or reflect the party ratio in the entire Senate. In the House, the majority party has much greater control, and therefore the ratio in the most important committees, especially the Rules Committee, which typically has two members of the majority for each member of the minority, plus one extra majority member, and the Ways and Means Committee, are a supermajority in order to protect their control. See Chapter 3 for a more detailed discussion of committees and subcommittees. And here are the review questions. Why would the framers want one chamber to be comparatively less responsive to public opinion than the other? What are the principal tools for the majority leader to use to run the Senate? How are Senate vacancies filled? How does this differ from filling vacancies in the House of Representatives? What are the comparative sizes of the House and the Senate? In the House, how do the voting rights of the delegate from the District of Columbia differ from that of the representatives from congressional districts in the 50 states? Who draws congressional district lines? What is the purpose, pardon, what is the process for removing a president under the 25th Amendment to the Constitution? Were senators always directly elected by people? If not, when did it change? How is the Speaker of the House elected? How does this differ from other House leadership figures like the Majority Leader and the Minority Leader? Why is the necessary and proper language in Article 1, Section 8 called the Elastic Clause? What is the significance of this language? End of chapter 1.